they are closed out by the rule of hearsay, because she cannot speak or vouch for the truth of such statements unless we are going to have this Enkalu on the stand to speak to this.
Well, my lord, again, my understanding, because I have a right as a party. Yes, my lord. My lord, because an application, my lord, rooted out of these cases, a party can rightfully object admission during trial. If I object, yes, my lord, if I object, then it behoves that the other side has to be heard on this issue, then if it is to be determined later. That's my understanding. Then we can receive a decision, unless they choose not to. Yes, because for specific.
I'm surprised by the objection on a number of reasons. Mr. Nambi referred to section 59 of the Evidence Act. Firstly, my lord, by dint of section 1 of the Evidence Act, that act does not apply to evidence. By dint of section 1 of that act, the Evidence Act, it does not apply to evidence. Secondly, my lord, the witness in paragraph 23 of her affidavit in support of the decision clearly states that what she is stating above is true to the best of her knowledge and belief from sources she has disclosed. In each of those paragraphs that my colleagues have referred to, the witness has stated the source of the information. She has stated the source on each single one of them. And my lord, there is nobody that she has mentioned who has not deposed an affidavit in this court. All of them, every person she mentions in any affidavit, in any paragraph rather, has deposed an affidavit in this court, and the record reflects that. Decisions are bound, my lord. It is only hearsay. If she states where she gets information from, and the person who she's getting information from is not before court by way of an affidavit, that's the only way you can call it hearsay. But where, my lord, she states that Kalule informed me, and she said Agent Kalule is here with an affidavit, that ceases to be hearsay. And all of those affidavits of persons she referred to in her affidavit are before this court by way of affidavits. Now, my lord, I also tend to think that we are reading from different decisions of West and Seven. My lord, in that case, Mulenga, JSC, who was part of the lead decision, here that my lord I should read. I should, however, comment especially on affidavits required under Rule 4, Sub-Rule 7, and 83A of the Election Petition Rules to accompany the petition and answers there. The said rules require that those affidavits shall set out the facts on which the petition is based, and the respondent will rely on, as the case may be. Invariably, however, the parties have to rely heavily on factual information they receive from their agents and other witnesses in order to comply with that requirement. In my view, what Mulenga says, in my view, therefore, in relation to those affidavits from those other agents, Order 17, Rule 3, which I think back now is 19, of the CPR has to be applied with such modifications as permits the petitioner and the respondents to include in those affidavits facts which they depend on such information. My Lord, that decision was referred to by the Court of Appeal in the case of Mpanga, Farouk versus Enkalu Isaac, and I'm reading from that decision. After quoting all of that, my Lord, the Lordship said in the Court of Appeal, after quoting that part of the decision, that in the instant case, a reading of paragraphs 5A to M of the petitioner's affidavit, just like in this case, my Lord, shows that what was stated therein was information based on what was provided from polling agents and supporters, as in this case. The petitioner, the Lordship said, the petitioner clearly disclosed the sources of his information, who also saw affidavits in support of the said allegations based on their knowledge, as has happened in this. Then they held, the Lordships in St. last round of elections, they then held, we find that the learned trial judge found that the disclosure of sources of information by the petitioner was sufficient, following the majority decision in Ageesigika versus Museveni. That was the holding of their Lordship. It's not here. Allowed in Munindo, Rehma. Munindo Rehma versus Winfred Kiza, EPA number 29 of 2011. The Lordship said that in these cases, the candidates rely on appointed agents, and as such, should have included that specific source of information, as has happened here. In the affidavits, or else they file separate affidavits from the agents who witnessed the occurrences. That is what we did, my Lord. And the Lordships then held that the learned trial judge cannot be faulted over this aspect. So my Lord, our submission is that first, the evidence Act relied on doesn't apply to affidavit evidence. Two, the petitioner has disclosed all manner of sources of information. Three, those persons from whom she has sourced that information have all deposed affidavits and their own court record. Number four, then the Lordships held that ceases to be hearsay. Of course, the Lordship, my Lord, is a candidate is not expected to be in each polling stations out of the 197. She relies on information from supporters, from campaigners, from agents. It is only hearsay if she says, Mosisi told me this, and there's no affidavit from Mosisi. If that the case is, the affidavit is there, that ceases to be hearsay. I'm obliged, my Lord.
Yes, my Lord.